Koutou katoa. Thanks to Carwyn and to Mark for the invitation to be here. I always like coming home for a bit, especially to be in the company of so many friends and interesting people. Listen, I know time's short, so I'm just going to jump into my comments today. As you all know, efforts to protect Indigenous rights can appear in human rights law as a form of prohibited racial discrimination. And my central point today is that because of this problem, we should be very wary of subsuming the treaty within our human rights frameworks and methods, including those set out in the New Zealand Bill of Rights Act and the UN Declaration on the Rights of Indigenous Peoples. So broadly speaking, the aspect of interpretation I'm addressing today is the treaty context. And I want us to be conscious of the rights that the treaty is in company with and in competition with, and how that might affect the way that we give effect to it in New Zealand law. Some of those rights, of course, emerge from international law. So to provide some context, I want to say, first of all, how the anti-discrimination problem appears to me as a question of political theory. And then I'd like to discuss some of the ways that other settler states have grappled with this issue. So the tension between historic collective Indigenous rights and individual human rights is, of course, a long-standing and very difficult one. Historic Indigenous rights are typically claims to traditional territories, property and governance authority, and to the jurisdictional relationships that flow from the exercise of those rights, consultation, entitlements, power-sharing arrangements, and so on. And these are almost by definition not claims to an equitable share of primary goods on terms equal to those of other individuals in the society. They are claims to particular property and powers, those that were held by the predecessors of Indigenous communities and have been or should have been inherited by their descendants. This means that the content of Indigenous rights of this kind is not necessarily, or as a matter of principle, capped out by concepts of equality. This means that certain Indigenous rights have a justificatory base that's premised on continuity, not equality. And it's this fundamental difference that makes them difficult to shoehorn into prospective liberal human rights arrangements without doing them some serious damage. Because of this tension, New Zealand, like the other settler states, has had to grapple with and try to reconcile two forms of liberalism. Now, the first is a classical liberalism, which, as you know, is forward-looking, directed to the maintenance of equality and anti-discrimination norms, the rule of law, and the just allocation of resources and primary goods amongst members of the society. But the second form, which I call reparative liberalism, has a more constitutive aspect. It looks back to the establishment of the state to address the liberal concept of consent, which we've heard about today, and the social contract that underpins just liberal democratic governance. Now, the persistent lack of Indigenous consent to settler governance arrangements threatens to undermine those states' legitimacy as liberal democratic institutions, and the restoration of Indigenous property and governance authority that offers a way for settler states to negotiate Indigenous consent. But it also entails the redistribution of primary goods in a way that can appear to discriminate against non-Indigenous individuals and communities. So in this way, the mechanisms used to further prospective and constitutive liberalism in settler societies are partly in conflict. And it's this tension that's very evident in efforts to reconcile human rights with Indigenous rights in international and in domestic law. Now, I'm very conscious these days, living in Australia in these interesting times, of how badly things can go wrong when there's no vehicle for Indigenous rights other than anti-discrimination law. Because what tends to happen is that Indigenous rights, because their justificatory basis is less sound in liberal history, they tend to be subordinated automatically to the rights of individuals to be free from discrimination. So the point I want to make is that in New Zealand, the treaty provides an additional and very powerful justification for Indigenous rights that does not place those rights in direct competition with non-discrimination principles. What I'd like to now do is to outline the methods used by courts in settler jurisdictions and in international human rights bodies to address this anti-discrimination problem. And my aim here is to imagine how treaty protections might be or should be conceived in New Zealand law if they were, which I think might be inevitable, if they were to be challenged at some stage as being racially discriminatory measures. Naturally, that might happen as a result of those claims being funneled through the Bill of Rights Act. Okay, so I wanted to speak about three different ways that states and international bodies have grappled with the anti-discrimination problem. The first is special measures, the second is specific rights, and the third is legitimate differentiation. So special measures are measures that differentiate on a prohibited ground, such as race, but they are saved because they are thought to contribute to substantive equality. And in international law, as some of you may know, these appear in the Convention on the Elimination of All Forms of Racial Discrimination in Articles 1.4 and 2.2. Special measures are allowed and in some cases required to secure the adequate advancement of racial groups disadvantaged in the enjoyment of human rights and fundamental freedoms. We have an equivalent here in Section 19.2 of the New Zealand Bill of Rights Act. The Canadian Charter has an equivalent provision in Section 15.2. And in Australia, the Federal Racial Discrimination Act, Section 8, directly cross-references to the CERD Convention provisions. So there's no doubt that special measures can be used to save some laws and policies that benefit Indigenous peoples from being disallowed as discriminatory measures. But they have a very awkward fit with measures designed to protect Indigenous historic collective rights. Because special measures must be premised on disadvantage, and some historic collective Indigenous claims are not, or at least the content of what is claimed is not measured by a group's current material disadvantage. Special measures must also be brought to an end when substantive equality has been achieved. So in the words of the CERD Committee, they cannot lead to the maintenance of separate rights for different racial groups. They must be temporary. And they can also facilitate governmental unilateralism, because there's a very high degree of uncertainty in domestic and international law about the concept of adequate advancement and whether this correlates with benefit, and if so, how. So I want to show the shortcomings of the special measures approach by reference to a 2013 Australian High Court decision, Maloney and the Queen, in which special measures were successfully relied on by the state of Queensland to defend the criminalisation of alcohol possession in an Indigenous community on Palm Island. They had imposed similar sanctions in 18 other communities, all Indigenous, and they had not imposed such an alcohol ban, criminalised alcohol, in any non-Indigenous community in the state's territory. The High Court was of the view that the measure was discriminatory on its face, but it was saved as a special measure because it was designed to secure the adequate advancement of that community. And they further held that a special measure need not be accompanied by consultation with the proposed beneficiaries of that measure. So that in Australia, at least, special measures, otherwise known as affirmative action, support coercive laws that significantly burden the community so long as that burden is plausibly directed to their advancement as a community. And this is sadly for now what passes for affirmative action in Australia. The court also said that special measures are the only exception to what might otherwise be racial discrimination under the Racial Discrimination Act. So other methods, such as legitimate differentiation, which I'll speak to shortly, are no longer permitted. Okay, because of the trickiness and the inadequacies of special measures when we're dealing with historic collective rights, two other approaches are emerging in international and domestic law. And the first, which I can deal with in short form, is specific rights. The CERD Committee produced a general recommendation in 2009 which outlined the difference between special measures and what it calls permanent specific rights that are owed to particular groups, and specific rights include the rights of Indigenous peoples to lands traditionally occupied by them. Now, there's very little explanation in the general recommendation that explains why these rights and why these groups. The other two groups mentioned were cultural minorities and women, where those rights correlated with biological difference, permanent specific rights for those groups. This lack of explanation, or lack of a theory, in other words, makes it difficult to see how they might be balanced with the rights of others, and very difficult to determine how the concept might be used domestically. As far as I know, so far it hasn't. But it is a big advance, especially for international human rights law, and we might turn our minds to whether it helps or could help with the protection of treaty rights here in New Zealand. This may have been, in fact, what the Third Committee had in mind in their comments in 2007 on New Zealand's 2007 periodic report. I might have to skip a bit, but I'd be happy to do that. The committee is concerned that in the report of the state party, historical treaty settlements have been categorised as special measures. The committee draws the attention of the state party to the distinction to be drawn between special and temporary measures for the advancement of ethnic groups on the one hand and the permanent rights of Indigenous peoples on the other. That's their instruction to the New Zealand government. The third category, the third method for resolving this anti-discrimination problem is legitimate differentiation that also emerges from the Third Committee and from the Human Rights Committee. And the way that I think about legitimate differentiation is that it's an ex-ante limit on what can constitute discrimination. So it's a way of avoiding a discrimination-based analysis rather than making an ex-post exception to it. That's the way that special measures operate. Okay, in international law, certain forms of differential treatment, while premised on prohibited grounds, are deemed to be non-discriminatory because they are reasonable, objective, and directed towards a legitimate aim. As a method for handling treaty rights, if they were challenged under the New Zealand Bill of Rights, this could be very useful. Paul Rishworth has raised it as a possibility in some of his writing. None of the cases I could find at the international level dealt with the rights of Indigenous peoples. Only one deals with legitimate differentiation on the grounds of race, and that was a case finding that a requirement that recipients of Danish car insurance speak Danish did not discriminate against them on the basis of race. There's sort of a different order to the types of claims that we might expect to arise when we're discussing the treaty. Okay. Legitimate differentiation has also been used by some lower courts in Australia as an alternative to special measures, but in what I think are very dubious circumstances. So again, words of caution. What happens when we don't have a treaty to rely on? Lots of horrible stuff. So the courts used legitimate differentiation in two cases. In the first, a state government had resumed control over an Indigenous reserve because of the level of alcohol-related violence on that reserve and had excluded certain members from entry to the reserve, thereby limiting their property rights. Rather than decide this was a special measure, the court simply held that it was reasonable, objective, and directed towards a legitimate aim. In the second case, the state government revoked liquor licences from Aboriginal Shire councils, but not other councils, and again the federal court thought this was a policy in pursuit of a legitimate aim, and so not discriminatory on its face. Okay. In any case, everything seems to turn on what the courts are prepared to accept as a legitimate aim, and this is a precarious concept, it seems, especially in Australia. If it were to gain any momentum here, we would certainly want to keep an eye on that. But we can imagine that one way to avoid subjecting the treaty to an anti-discrimination analysis would be to say that efforts on the part of the Crown to meet its treaty obligations are always a form of legitimate differentiation. So they don't pass the threshold test and they're not subjected to an anti-discrimination analysis. However, the possibility that this could happen is becoming less likely in the face of the New Zealand Court's jurisprudence on Section 19(1) of the Bill of Rights Act, the non-discrimination section. Courts have given the section a very wide reading, effectively characterising most forms of differentiation on prohibited grounds as prima facie discriminatory and leaving the proportionality test to Section 5, which many of you will know, allows limits on the rights of an applicant if these can be demonstrably justified in a free and democratic society. So it seems to me that whatever the justifications we might offer for laws protecting Maori treaty rights, for the time being these must run the gauntlet of Section 19(1) if they were directly challenged, and this is a little bit hair-raising, I think. So are there other approaches, my concluding section, that we can use because we have the treaty here, approaches that may not be available in other jurisdictions or may not be available to international bodies? And I think the answer is yes. The treaty does offer us a way out of the impasse. But I think what it requires is for us to conceive of it as something other than simply a statement of rights. And here I'm going to echo things that other people have said. Helpfully for me, I was very cheered to hear them earlier. The treaty is not only foundational, it's constitutive, both of New Zealand the polity and New Zealand the state, including our government. It is a very powerful manifestation of New Zealand's settler social contract, and it shows the conditions attached to Maori consent in the newly formed state of Aotearoa, New Zealand. I think then we can begin to think of it as a precondition of the just and formally equal allocation of rights and resources within and among other members of the settler society. In other words, it limits the kinds of things that the government can legitimately commit itself to vis-à-vis non-Maori members of the community. Now, I was very taken with John's astute comments in the chapter that he circulated, where he spoke about the common function of individual rights and Aboriginal rights being to serve as a limitation on governmental power. That makes perfect sense to me. I wonder if we can take that idea and expand it in our understanding of the treaty here. Perhaps it's better to think of the treaty as establishing a kind of New Zealand federalism, and I just spoke to Ned about this. I'm so glad he said that. It made me feel very confident that maybe it's a good idea. Okay, it is of course a North American idea. North American Indigenous scholars have spoken about treaty federalism in their context to explain a matrix of agreements that is constitutional, even though it sits above and alongside the formal written constitution. Okay, so then we would have to think about it as a document that establishes the just allocation of exclusive and concurrent powers amongst Maori polities and the settler government. Now, this is not a new idea. I realise it's deeply embedded in the idea of the treaty as a Magna Carta, but it does tend to get lost once we start talking about human rights. There's a very powerful impulse to characterise the treaty as a statement of Maori rights, and that's perhaps because, as other people have said here today, the imprimatur of rights has become so powerful we can't think of this as a jurisdictional arrangement in the same way that we might, and we've lost some of the traction of that way of thinking, I think. Okay, this is of course part of the appeal of the United Nations Declaration on the Rights of Indigenous People, which does, as many people forget, include a provision that says Indigenous peoples have the right to have their treaties enforced, but as you know is also bookended by equality provisions. So there are very many problems that attend the interpretation of that instrument that I would like us to avoid in the way that we regard the treaty itself. Okay, I'd just like to finish now by being conscious of Bain's comment that we should be aware of rhetoric when we hear it, to report a bit of rhetoric from Lord Cook, see what you think about it. He said in his 1993 comment on the Declaration on the Rights of Indigenous People, which was then just a draft, "The message I want to convey is that we have a precious thing, a truly distinctive thing in our Treaty of Waitangi and the principles of partnership that have developed from it. Let us cling to that. No doubt the International Declaration is useful and some inspiration may be obtained from it, but it's the treaty itself that is central to our community and to our way of life." Kia ora.